No, Your Honor.
All right, let's go on the record on DC 209573. Carlos Torres versus SAV Enterprises LLC. Counsel, make your appearances.
Justin Smith here on behalf of the plaintiffs, Your Honor.
Dan, you're muted.
Thank you. I'm sorry about that. Your Honor, Daniel Cart for Premier Option Credit LLC, DBA Sunbelt Pawn.
Sonia Garcia and Ryan Fellman here for defendant SAV Enterprises.
Okay, we're here on a pre-trial for a trial that's set to start tomorrow. We can deal with some of this tomorrow morning, but I know there's some things you guys wanted to cover. We'll go ahead and start off with plaintiff's motion in limine. Do the defendants have any objections to any of this motion in limine?
Yes, Your Honor. Maybe just for note-keeping purposes, I'll recite which motion in limine items are agreed, at least insofar as SAV goes, because I want to make sure I took proper notes. Justin, does that make sense to you?
It does.
Okay.
Well, and let me just ask this, is there a difference between the two defendants on what's agreed to? Because I'm going to mark this.
Dan, I want to
Let's just
speak for
go
you.
through
Let
one at
me
a
list
time.
out, and then I don't know.
Let's do this. We're just going to go through one at a time.
Sure.
And then you guys will say agreed or not agreed, and we'll hear argument. So paragraph 1, is it agreed to?
Yes.
Yes.
2,
Yes.
Agreed.
3,
Yes.
Yes.
4,
Go ahead, Ryan. I was going to say agreed for me, Judge, as long as it's mutual.
Same.
okay. 4 is agreed and mutual. 5,
Your Honor, for 5 through 8, we agree so long as made mutual.
Mr. Carp.
Same, Your Honor.
5 through 8 are agreed and mutual. 9,
Your Honor, for 9 through 14, SAV is agreed.
And I am agreed as well, Your Honor.
9 through 14 are, so all of them are granted, and I guess 4 through 8 are, or I guess 1 through 14 are granted. 4 through 8 or sorry, yeah, 4 through 8 are mutual. All right. What about 15?
15, I'm going to defer to Sunbelt Pawn. Does Sunbelt Pawn have any objection to 15?
No, we don't have an objection, Your Honor.
All right, then we don't as well.
15
Right. The only thing I would not want to run afoul of is every once in a while we have this, we agree, and somewhere in the thousands and thousands of pages of medical records may be a statement some nurse or doctor says about he was taking too much of this or that. But other than that, we're agreed. And I just don't want to run afoul of the court's order if there's some random line somewhere in the medical records.
Before the medical records and exhibits go back, they're going to, each side are going to have an opportunity to look at each other's and, you know, redact that stuff if it's in there.
Okay.
All right, 16.
For 16 through, let me make sure I get this right. We're agreed on 16.
Okay. Agreed as well.
16 is granted. 17.
Your Honor, 17 all the way through 19, we're agreed.
Same.
17 through 19 granted. 20.
20, not agreed. I'm not exactly sure what the intended scope of 20 is.
And same, Your Honor, in the event, and they have listed that they will be calling a vocational type expert, et cetera. I think we have to be allowed to obviously cross-examine that witness as to economic damages, jobs that the plaintiff can or cannot do, things of that nature. And I think the way 20 is so written, it's overly broad that it would prohibit us getting into any of that.
Yeah, it does, Mr. Smith, it does seem overly broad.
What we're really intending to do here, Judge, is we've disclosed all of our calculations of those economic damages, and we don't have anything in their response to 194.2D that says that those calculations are incorrect. So we have some cross-examination from them that we'll probably get to on the page line designations for the two damages experts on the monetary side of things, which is a life care planner and a vocational rehabilitation counselor. Obviously, a lot of that cross-examination testimony is going to come in, and that's not really the issue.
Yeah, I'm not gonna grant 20. I think they can still challenge your amount. That they're not allowed to present an expert or testify as to what the amount of economic damages are, like have an alternate theory unless they've disclosed that. I agree, but they can still challenge your what yours are. So unless you can find some case law to the contrary. So 20 is denied. All right. 21.
Your Honor, on 21, I'm unclear as to what the intention is, as to what the plaintiff or his counsel would consider a windfall argument. I mean, to be clear, a major issue in this case is contributory negligence. So I don't want to run afoul of a motion in limine by arguing that the plaintiff is responsible for his injury, so to award him any damages would be a windfall, because I believe that's what the evidence will show. So I don't know if we have a dispute here. I don't know what the intention is behind 20, but that's why I can't agree to it.
Mr. Smith.
Well, I don't know that I really understand the connection between contributory negligence and awarding damages as a windfall. I mean, the jury's tasked with determining the liability questions and awarding compensatory damages. Those are two distinct issues, and they're not supposed to be informed that any answer to any question on a jury charge should affect any other answer on the jury charge, except for the instructions that the court gives them as to how they are supposed to go about answering questions. You know, for example, answer the following question if you answered yes or no to the prior question. So the whole point of compensatory damages is to award the damages that fairly compensate the injured person for injuries, if any, that sustained as a result of the occurrence in question. Saying that awarding those damages are windfall is an improper argument.
I think my response to that is I don't think I disagree with anything you said. And to be clear, I didn't have it in my mind to use the word windfall, but I want to make sure we're talking about the same thing, because we all know that if the jury finds Mr. Torres 51% or more liable, he doesn't recover any damages. So of course there will be evidence and there will be closing argument about who's responsible for the incident in question. I just want to make sure I wouldn't run afoul of some motion.
Yeah, just 21 is granted. You can't use the word windfall.
All right. I just want clarity on that.
22.
Two. I'm going to defer to my co-defendant on that one.
Your Honor, I'm basically fine with it. The only thing I want to make sure it doesn't cover is he did testify he has an estranged son. So in the event that child was to show up and testify, obviously we'd have to get into the relationship that existed. But since I don't foresee that, I'm fine with it as it is right now. We can always address it at trial if the need arises.
So I'm a little confused what you just said. So he has an estranged son and.
Right, and I don't know if that child was planning on showing up at trial to testify about how his dad's been hurt, injured, their relationship's been suffered, whatever. So I'm not interested in going into any prior marriage he might have had.
But you're not going to be able to argue, because if you look at what it says, so if he has an estranged child and the child comes to testify, you can talk about the relationship. I don't want you to come in and say, aren't you the bastard son of Carlos Torres or something like that. That's
no. Yeah, I'm not
gonna Game of Thrones. So
As it gets into legitimacy, that word, I will not be challenging legitimacy at all, and I have no issue with 22 as written.
Okay, 22 is granted as written.
Okay.
All right, what do we got next?
23, we are opposed. This this case involves a gentleman who decided to use gasoline on a floor in a confined space, and it eventually ended up igniting. And so I think I need to be able to get into gasoline and the fact that it's flammable, and people know not to have sources of ignition around gasoline, whether that be cigarettes or anything else. And it's just kind of common sense argument. So I don't understand the purpose or the point of 23 and it's how it's stated.
Mr. Smith?
Mr. Torres was not smoking cigarettes while using gasoline. And if Mr. Carp is going to start cross-examining him on something that he wasn't doing, that is unfairly prejudicial and not relevant. If he wants to cross him on the dangers of gasoline, that's fine. But that's a hypothetical to a lay witness that is not appropriate.
Yeah, I'm going to grant this for now, just on the issue, because this really seems to cover just cigarettes. If there is some evidence that there was cigarettes, you want to lay a foundation on that, you can approach. But is there any evidence that he was smoking cigarettes?
No, and my bigger concern was using examples to the jury of gasoline, and everyone knows not to smoke when they're filling up their car or something like that. I didn't want to stumble into. I'm not accusing him of smoking, to be clear, but I just didn't want to run afoul of eliminate.
I think the jury's going to know that gasoline is flammable. So let's go to that one's granted. 24.
Your Honor, on 24, I'll let Mr. Carp speak because his client was the employer, Mr. Torres, not mine.
Yeah, I think to the extent he's making a claim for lost wages, Judge, I need to be able to discuss the fact that he hasn't paid taxes in 11 years because under 18091, it has to be reduced from taxes. And so I think I need to be able to get into that and make the jury aware of that if indeed he is pursuing a lost wage claim.
I don't think that his tax-paying status prior to this incident had anything to do with the lost wages or lost earning capacity. And as Mr. Feldman noted, Mr. Torres was employed by Premier Option Credit, and we asked for all the pay stubs, W-2s, 1099 forms, everything that they had regarding his compensation. And nothing was produced to us. And I think that that's because, and we'll get into this a little bit later, Mr. Torres' legal status is not documented. And so Premier Option Credit, Sunbelt Palm, was paying him in cash. And as his employer, they would also have an obligation to withhold from his
24 is granted. 25.
Your Honor, on 25, this I think is a big legal and evidentiary issue in this case, as Mr. Smith just foreshadowed. But let me provide some context as to why we can't agree. First, just speaking for my client, there is no dispute that ordinarily someone's immigration status would have nothing to do with a case like this. Would be totally irrelevant. On that, I agree. But here's why it's not true here. Based off the exhibits that are on the plaintiff's exhibit list, there are many exhibits that get into the issue of what my client and some other witnesses told the fire department after they responded to the incident. So let me give some context for the court. Mr. Torres catches fire. One of the other gentlemen there calls 911. Paramedics show up. Fire department shows up. Fire department begins their investigation. Now, it is undisputed, and this was discussed at length in my client's deposition, Sabino Venegas. He's asked, was he honest with the fire department when they were asking him, how did a can of gasoline get out in like a dumpster area outside the building? And he told Mr. Smith, who was questioning him in his deposition, that he did not tell the truth to the fire department about who put it there. And he was asked in his deposition why. And he said, I didn't want to guilt him. I didn't want to get him in trouble. Him being Carlos Torres. There are also some videos, some like body cam videos of the fire department officials questioning Sabino Venegas and another gentleman, Jose Blanco, who works for the co-defendant. And what's not going on is no one on behalf of the fire department is questioning Sabino Venegas or anyone else about who instructed Carlos Torres to use gasoline to clean the floor. That never comes up. And it's unsurprising because the fire department is unconcerned with tort liability. They're not trying to figure out who told him to do something. In fact, he outright says—
What does that have to do, I guess, with his immigration status?
Yes. So let me, Your Honor, so I was just about to get there. So here's what's going on. What's going on is Sabino put the gas can outside because in his mind, he doesn't want Mr. Torres to get in trouble. And the trouble that he's concerned with is he doesn't want him to get in legal trouble because he doesn't want him to get deported. And it's not just Sabino saying this.
You stop there. I'm going to grant that and I just want to make clear, if anything comes out on immigration status in this case, I'm going to mistrial and sanction the party involved. So we're not going into immigration status, so we're not going to try to backdoor immigration status in that way. So if I hear anything about immigration status, I want to make that 100% clear. That will be a mistrial, and I will award sanctions against anyone who does that. So let's go to 26.
Your Honor, I understand your ruling. You've made that very clear, but just so we have guidance for this trial, there is something that is important. And this dovetails with SAV's motion in limine, so we can get there in time, but I just want to foreshadow this for the court. You've made it very clear your ruling on immigration status. But if the jury is going to hear what Sabino Venegas did, they need to be able to hear the why. And so if the line for this trial is he can testify, I was trying to prevent Mr. Torres from getting in legal trouble, I just want to know that for clarity's sake, because that is the truth.
That's totally different than I'm worried about his immigration status or that he's going to be deported. You can't go into the fact that he could get deported. You can't go into the fact of he was worried about his immigration status. I'm not going to let you backdoor immigration status.
No, I understand, Your Honor. And
you can say, I was trying, if he says, I don't want him to get, is this going to be by deposition? Or is this going to be in person?
This is going to be in person. He's the one and only owner and member of SAV Enterprises.
And Your Honor, to be clear, it applies to my folks too, who are also, two of them were at the scene, also told the fire department similar type things. My concern and why this comes up, Mr. Smith has pushed this issue hard that because my folks and Mr. Venegas lied to the fire department, that somehow creates culpability as to liability. So they lied because Mr. Torres has testified. These guys were like family for 10 years. They ran around the state doing this stuff together. They're all friends. And the truth of the matter is, and I understand the ruling, they were trying to cover up for the guy because they didn't want him to get deported. So to the extent Mr. Smith is going to try to use these records to say, oh, look, these guys lied, therefore they're guilty, it would be highly prejudicial for my clients to not be able to explain the why. And I'm happy to do it in a way of just saying legal trouble or however we want to phrase it. But
legal troubles is fine. If you bring up immigration status, I want to make this 100% clear at this point. I'm going to mistry the case and I'm going to sanction your clients. I just want to make that clear. You need to talk to this is like a plaintiff not being able to bring up insurance in a car accident case. You got to instruct your client. They cannot bring that up. And I don't know what else to tell you, but you cannot bring up immigration status or deportation or anything else like that.
We understand, Your Honor.
All right. 26.
26, we are opposed. Your Honor, Ms. Cardenas was a party. She's no longer a party. And to the extent that has occurred due to changes in their spousal relationship, emotional well-being. We've got mental anguish in play in this case. I think we need to be able to potentially get into that.
Is she the spouse, I guess, of the plaintiff?
Yes,
Okay, and then she was a party, but then they non-suited her claims. Is that the deal?
yes,
Yes,
Judge.
Your Honor.
She was a party originally. Her claims were non-suited back in December or January of this year. That is an amended and superseded pleading, and the only role she'll play in this trial is to testify as a fact witness.
I mean, I don't. All this is asking about is she was a party, and I guess she's not one now. That's you're not allowed to go into that, but you can go into their relationship. I'm not sure if that covers it.
No, they can go into the relationship all they want to. Just the
Yeah.
fact that she was a party and was pursuing claims at one point in time, but isn't that?
Does that make sense, Mr. Carp?
It does, Your Honor, and if somehow under that cross-examination, it opens the door, we'll approach at that point and can discuss. No
Okay.
problem. Yep.
27.
No objection for SAV Enterprises.
No objection.
28.
No objection from
No
me.
objection.
All right, that's all the plaintiff's motion. Okay, let me see. Is there anyone here on any other cases? Okay, all right.
Oh, sorry, Your Honor. I think we saw a Bob's Ultra. I think that could be opposing counsel in our case.
Is that with you, Ms. Garcia? You're talking, is that what were you saying?
Okay, that's Bob Bragalone. He's with Gordon and Reese. He's with Sonia and me.
Oh,
Yeah.
sorry about that.
Mr. Bragalone, you need to have your name on the on your screen. Who's Brittany McDonald? Is she with y'all?
Brittany McDonald is not with my firm.
Nor with mine.
Mr. Smith?
No, Judge. I don't.
Ms. McDonald, what are you here for?
Can you hear me now?
Yeah.
Okay, I'm so sorry. I'm here with case number 07899, Laura Gonzalez.
For Laura Gonzalez. Okay. Oh, the prove up?
Yes, sir.
Okay. And are you guys proving this up today?
I believe so, yes.
Is your client here?
No.
So what tell me what how are you going to prove it up without your client?
Oh, I'm sorry. Can I? Yeah. Well, then I guess we're gonna have to reschedule.
Because we reset this from last week so that you could do I think we reset this from last week so we could do it's the 7th reset.
I'm brand new on the case. I just got it this morning.
Okay, this has been set 7 times on the DWAP docket, and so you're gonna I'm sorry you kind of been thrown into this, but you guys need to get this proved up by next. It was supposed to be proved up this morning.
I can possibly do it by next week.
Guys, how long is this trial going to take?
I suspect, Judge, it's going to take 4 to 5 days.
Yeah, I'm not going to have time this week, Ms. McDonald. Why don't you talk to whoever was in charge of this case before and find out what's going on, because you guys were supposed to be here at 9 for a prove up and you weren't here, and we reset this 7 times. So try to find out what's going on and you can sign back on.
Okay, thank you.
Okay, let's deal with the defendant Venegas versus Premium Option Credit LLC's motion in limine.
That may have come out a little, just for simplicity's sake, let's call my client SAV. And Mr. Carp, what do you want to refer to your client as?
Sunbelt is fine if that works for everybody.
So
Sunbelt?
Sunbelt?
Sunbelt. Okay. So because SAV has a motion in limine and Sunbelt, do you have one?
It is.
Okay.
So
Do we
there's-
want to do SAV? Are we fine with?
okay, what I have here is defendants Wilbur Antonio Venegas, Jose Blanco, and Premier Option Credit LLC. Is that SAV?
Oh, that's Mr. Carp. My apologies.
Is that Sunbelt or SAV?
That is Sunbelt. And
Sunbelt,
to
okay.
be clear, the two individuals have been non-suited, so now it should just be the Premier Option Credit LLC, and then SAV Enterprises are the only two remaining defendants.
All right, Mr. Smith, do you oppose any of defendants' defendant Sunbelt's motions and limines?
I do have a couple, Judge. Shall we run the same process? And I'll just tell everyone which ones I'm agreed to, so we all have that. And then some of these I don't think I'm opposed to, but I need some clarification either from the defendants and from the court.
All right, what do we got?
Plaintiffs are agreed to number one. On number two, which discusses the wealth of the parties, here is my concern, and here's where I need some clarification from everyone. Obviously, we need to talk about the relationship between the two entity defendants and the ownership of the property. And by that, I mean, Judge, for a little bit of background and context, Sunbelt Pawn is owned by Anthony Venegas. Anthony Venegas's father is Sabino Venegas, who owns SAV. SAV buys properties and leases them to Sunbelt Pawn, which is what was going on in this incident, where SAV had purchased this property, leased it to Sunbelt, and then they went to go renovate that property for the purposes of opening up as a new store location. Obviously, talking about what SAV does as its business in buying properties and leasing them to Sunbelt Pawn, both generally the relationship between them and specifically the relationship that brought everybody out there to the scene that day, is relevant and something we're going to get into, and tangentially deals with wealth.
That's not what this covers. I'm not worried about that.
Okay.
Number two is granted. What else do we have?
We are agreed to 3, 4, 5, 6, 7. With respect to the prior statements, a lot of this is going to be addressed in the objections to the exhibit lists and the deposition page line designations. It's already been alluded to. There's a host of prior inconsistent statements and statements.
Number 8 is denied.
We are agreed to 9, 10. On 11, we need some clarification for the court on how it draws the line when we are doing.
I do this the same in every trial. You can just ask who's involved in the claims, but that's as far as you can go on voir dire.
Who is involved in claims? Okay,
For handling claims.
For handling claims. Okay, with that clarification from the court, we're agreed to number 11. On 12 and 13, these are two of these general motion and limines that I don't really know what they're intended to address, nor do I really know where the lines are. So if the defendants can tell me what they're concerned with, maybe.
Is there anything in particular you think he hasn't pled or disclosed?
No, not off the top of my head. In fact, I talked to Mr. Smith about this the other day. I'm sure he's got everything pled, but it's just always to make sure no one shows up and does something crazy.
12 is granted. 13?
It's the same issue, Judge. It's kind of a general motion in limine about asking questions of lay witnesses. And I don't really know what they're concerned about or where I would be stepping over the line.
Yeah, 13's a 9. You can just object as you go along.
We are agreed to 14 and 15. 16, I'm agreed
Give
to.
me 1 second. Give me 1 second. Sorry.
Sure.
Sorry, there wasn't a thing to fill out for 13. So 13 I denied. What did you say? 14 is
Agreed.
agreed. Okay.
15 is agreed. 16, I'm agreed to. There's a statement down there at the bottom about similar adjectives. I don't know what similar adjectives means. I don't have any problem not saying someone's a designated hitter or a mouthpiece or a hired gun. But I don't know what they would consider a similar adjective to that.
I mean, I've never had this come up, so I'm not super concerned. So just be careful about those 3 words.
Okay. And with that, I'm obviously agreed to those 3 words, Judge. If they think that I've used a similar adjective, I'd like them to object and tell me what
Yeah,
that.
if it's something, anyway, I'm not worried about it. What else do you have?
On 17 or 18, it's not clear to me whether or not that is intended to address what's already been alluded to, which is the fact that after the incident, much of the evidence was hidden at the scene, because it makes reference to any subsequent conduct to the incident. I don't think that hiding the evidence is a subsequent remedial measure under 407. And to the extent that it's intended to address that conduct, I don't think that's
so anything that happened right after the accident, I don't think would be a subsequent remedial measure. Is there something in particular concerned about, Mr. Carp?
Yeah, Your Honor, yeah, this goes back to what we talked about, which is Mr. Smith is going to allude that because my clients moved the gas cans outside or tried to prevent the fire department from seeing them, therefore they were culpable in causing the accident. And that gets back to the explanation of why they did it, obviously, because they didn't want the guy to get in trouble because he'd been their buddy for 10 years. So just
I think we've discussed that. We know what the parameters are, so I think we're good. All right, what's next?
Just for clarity's sake, so on 17 and 18, where are we? Is it agreed?
They're granted. I just want to make clear that that's not a subsequent remedial measure, the moving the gas cans. But
Okay,
if there's some other subsequent remedial measure, I would grant that.
I'm not aware of any subsequent remedial measure that was designed to make anything safer. I do want to get out here right now while we're talking about it that what was moved from the scene was 4 gasoline cans, Carlos's clothing, a melted broom, and a mop bucket. So that's
yeah, let me respond to that real quick. So for SAV, I don't characterize anything that happened post-incident in this case as a subsequent remedial measure. I agree with you, Mr. Smith, as to that. There is different testimony as to actually what occurred, not that 4 gas cans were taken. 3 were already back there from prior jobs that were done in the 2 weeks prior. But anyway, we don't need to get into those details. But other than the 3 gas cans that were already there, the undisputed testimony is that 1 gas can and some of Mr. Carlos's or Mr. Torres's clothing and a broom was taken out back.
Okay.
I don't have necessarily to say that. We've got fact questions on whether those 3 gasoline cans were already there, but that's not really relevant right now.
Understood.
I don't. We're agreed on number 19. Number 20. I don't know exactly what that is intended to address. Obviously, they have some claims pled and some assertions pled. And
that's just that's boilerplate. I mean,
I agree, it's boilerplate.
Yeah, I don't. I mean, I can't even imagine how that would come up in this case. But I guess is there a negligence per se claim? Maybe.
No.
No, we can withdraw number 20, and that way it's just more clear.
All right, number 20 is withdrawn.
We're agreed on 21. On 22, we have an objection to number 22.
I mean, I think under Cortez, I don't think you can do that, can you?
You can ask about awarding dollars, but not a specific figure.
I'm not familiar with the Cortez case, Judge, so I'll rely upon your recollection of it. And if that's what it holds, then we'll agree to number 22 and not question about a specific dollar amount.
Okay.
On 23, the only issue I have with that on 23 is right now we have gross negligence and punitive damages claims pled. I think those arguments are appropriate for punitive damages. I know that SAV has a motion to bifurcate that's pending. So if it's granted, obviously we won't do it in the first phase of the trial, but would make similar arguments to that during punitive damages.
Okay. 23 is granted, and I would, if there's a motion, I mean, I would usually grant that if it's to bifurcate the punitive damages, just so we do that.
On 24, I don't have any issue with any of the specific things that are listed there. It's the same thing that we talked about with similar adjectives. It has appeals of a similar nature. I don't know exactly what that means, but to the remainder of those specific things, we're agreed, Judge.
Okay.
24 is agreed. 26 is the same issue that we talked about prior. There's a line on here of ownership of property.
So what about 25?
25 is agreed, Judge.
Okay, 25 is agreed to. Okay.
On 26, the only issue I have with that is that line there about ownership of property, which obviously is an issue in this case.
Yeah, and to be clear, Your Honor, we're fine if he wants to talk about who owned this building at the time of the incident. That's not an issue. What I don't want coming in is, well, how many other buildings do you own, and how much are those buildings worth, and all that kind of stuff, because that gets into net worth, which was on plaintiff's own limine, by the way. And so at the bare minimum, at the Met, it would be potentially relevant at a punitive stage, but certainly not on the compensatory side.
Correct. All right, 26 is granted, that understanding. 27. All right. We're gonna run out of time pretty quick. So let me, because I have other hearings I gotta get to. Let me just find out.
And Your Honor, I have to hop off as well. However, Ms. Washington from my office is here and can continue to the extent the court wishes to.
Yeah, let's try to get through. Well, I guess. Is anyone here on the Yanez versus Texas Wild Horse Creek case?
Yes, sir. Dick Holland for the defendant.
All right. What about with the plaintiff? Now, I was a little unclear. Was this agreed to, this motion to transfer venue?
Your Honor, it was filed by a prior lawyer. I substituted in. I'm out in West Texas. It's called unopposed, but I'm not privy to any conversations that anybody had. I believe it is. When I called to try to get the order entered, the court administrator said I needed to get a hearing set.
Okay.
If you want to finish with this hearing, I've got plenty.
No, I don't want to make you wait. Your time is scheduled for now. So if they're not here, then I assume that it's agreed to. So
I've not heard anything otherwise.
all right, I'll go ahead and sign that right now.
Thank you. May I be excused?
Let me just look at the order 1 second. Is the opposing counsel on your case, sir, Gastani Nimschnick? Maybe
It's the Hun firm from Houston. I don't know the particular lawyer that,
okay, let me. Is there anyone here on the Yanez, anyone else here in the Yanez versus Texas Wild Horse Creek Ranch case?
Your Honor, this is Gustaving entry for the plaintiff, Mario Yanez.
All right, do you guys agree to the transfer?
We do, Your Honor.
Okay, I'm gonna go ahead and send that in right now. All right, you guys are excused.
thank you.
And then Miss McDonald, what did you find out?
I found out that the client is non-responsive, and even if she was, she's a Spanish speaker, and the previous attorney on this case did not arrange for a translator for this hearing. As far as I'm aware, Your Honor, I would like the opportunity to do this in the right capacity, but whatever you choose to do.
It's set for DWAP next Monday, so if you can get a translator and somebody there to testify, you can prove it up, or if not, then it'll get DWAP'd.
Perfect. Thank you so much.
We'll see you on Monday. Mr. Line, Mr. Campbell, did you find your opposing counsel?
Your Honor, I am still on hold with their office, and I don't know why Ms. Beaubier, they had somebody else from their office last week, if you recall. So we are trying to see if they have another lawyer that can hop on.
Miss Wright, is she here with you guys, Mr. Feldman or Ms. Garcia?
No, Your Honor, I'm here for the Pettigrew versus DFW stores in 7-Eleven case.
What do you have set for today?
Well, actually, it was just put on our calendars, but we already had our agreed uniform scheduling order signed.
Oh, okay, yeah, then you're not on the docket anymore, so you have a great rest of your day, okay?
All right, thank you. You too.
Thank you. Miss Matar, I see you signed back on. Do you have something? Okay, I guess you just. Okay.
Your Honor, when you have time after the hearing or the motion limited hearing you have right now, if we could call Ms. Beaubier's office and have her paralegal explain why. We're just kind of at a loss right now. We don't know why we can't get anybody from their office to hop on.
Okay. I need to have an attorney. I mean, there's nothing set today, so you guys were called down last week, so you need to be there tomorrow. If you can get the other side on the phone or on the Zoom, just let Rhonda know, but there's no reason for you to stay on here.
Yeah.
They're not, I mean, there's nothing set today, so there's no reason you should have known.
All right, thank you, Your Honor.
All right.
Thank you.
Okay, so back to Torres versus Venegas. I think we're on defendant SAV Enterprises LLC's motion in limine. Is there anyone here? I'm sorry. So is there any objection to any of these?
Yes, Judge. On number one, it has a reference to defendant does not consent to the trial of any facts or theories of liability damage not alleged in plaintiff's timely filed live pleading. Again, this is one of those kind of general motion in limines. I don't know that a consent or an objection to consent is really a motion in limine in this case. So I don't know what that is.
Your Honor, all that's designed to do, yes, it's a general motion in limine. I don't know of a specific issue here, but the motion in limine is designed to cover a situation where a plaintiff, untimely amends a petition to assert a new theory of liability or a new category of damage. That has not happened in this case.
Yeah,
The
one is granted. It doesn't apply anyway. What else do we have?
With all the clarifications that we've had on premier option credits,
Those will apply here.
those will apply here. And with that, number 2 through 10 are agreed.
2 through 10, everything that's been agreed to is granted, just so it's clear. All right, what do we have next?
We have 11, any references to conspiracy claim, cover-up theories, or spoliation of documents or other evidence. Obviously, we've talked about how that is an issue in this case.
Yeah, 11 is denied.
12 through 16 are agreed. I don't know what 17 is designed to address. I don't know where the line is on that one.
You know,
That's so broad.
yeah,
Number 17 is denied.
18 is agreed. If 19 is only addressed to experts who are going to opine about subjective knowledge, then it's agreed. To the extent it's about something else, then I'd like to know what that is.
yes, that's the intention of 19, is that an expert can't take the stand and say, in my opinion, they were grossly negligent or reckless.
Okay, that's agreed.
Okay.
Number 20, prohibited from offering charts or summaries of alleged damages. A summary of damages is permitted under 1006, and we can certainly offer one as
20
demonstrative.
is denied.
21 through 24 are agreed.
Okay.
25, I don't know how, I don't know what that means. Any questions calling on such witness to speculate as to causation? All I can do is ask questions and they can say they know or they don't know. So.
Your Honor, I don't know if there's a dispute on this. I don't think you're going to hear from anyone in this trial that somebody has some alternative theory as to what caused the fire to occur. I won't speak for Mr. Carper, his client, but it's crystal clear that gasoline ignited. So I'm not sure this is going to come up. I don't think it would come up.
Just so I know, what caused the gas to ignite? Like, did it?
Sure, Your Honor, and other counsel can chime in, but the facts are in this case is that they're in this commercial building. It's got several rooms. Mr. Torres is in a room, one of the offices, and what's going on is they're trying to get adhesive off a concrete floor, adhesive from prior linoleum tile. He uses gasoline to get the adhesive off. Down the hallway, I don't know, 20, 30 feet, there's a gas water heater. The fire department concludes that vapors from the gasoline must have ignited due to the pilot light of the gas water heater. Those are the facts.
Okay.
And I don't believe anyone disputes that. My client doesn't.
That's what happened, Judge. The water heater was 14 feet away, but aside from that, everything Mr. Feldman said is, in a nutshell, accurate.
All right. 25, I guess, is denied. Anything else?
26 is agreed. 28.
Your Honor, let me help out a little bit because I looked at 27 and it's unclear. So SAV agrees to withdraw number 27.
Okay.
Number 28. 32.
Wait, you were drawing 28 and 32?
Yes, Your Honor, and then there's two more.
Okay.
33. 38, because it's duplicative of number 1. And actually one more, 41.
The 33, 38, and 41, is that right?
Yes, Your Honor.
All righty. try to get through this. All right, 29.
29 is the exact same issue that we just talked about. I mean, we all know what caused the gasoline to ignite, what happened here. So I don't know
29
why.
is 29 is denied.
30, 31 are agreed. 34 and 35 are agreed. 36 is a general motion limiting on commitment questions. I think that's more appropriately addressed by an objection if they think something is a commitment question.
Yeah, I agree. Denied.
Personal beliefs. Obviously, we're going to be arguing the facts of this case and what we believe those facts support.
20, just so it's clear, 37 is granted. You can't just start, you know.
Saying
I don't think
by
any.
the evidence.
Thank you, Your Honor.
39 is agreed. And then we've got 40, which we've already talked about. Those are the post-incident actions of Sabino Venegas with regard to
40 is denied.
42, which is hearsay within hearsay. It makes a specific reference to the Irving Fire Department. I think
42 is denied. Okay, let's deal with exhibits now. Let's try to get exhibits admitted. They have plaintiffs amended an exhibit list. What is agreed to by the parties, by the defendants? Or I guess, are you offering everything on the list?
No, Judge, we're not.
Okay. What are you offering?
2A.
2A, okay.
Yeah, we're offering everything that's 2A, 2B, all of Exhibit 3, all of Exhibit 5.
Okay. Give me a second. 5, okay.
Exhibits 6A through C.
What do you say? 6A through C, is that what you said?
Yes, Judge.
Okay.
9A through H.
Okay.
And all of Exhibit 10.
Okay.
Exhibit 11.
Second.
Your Honor, I apologize. I just want to make sure, and Mr. Smith, I'm trying to keep track here. You said all of 3. Can you just, if you don't mind, can you just say that again?
Yeah, so it's all of 3, which is 3A through 3W.
And then you skipped all of 5.
Yes, 5A through D.
And 6.
You're not offering 4 right now, correct?
That is correct.
Okay.
We're offering 6A through C, 9A through H, 10A through Q, 11A through M, 12A through F, 13, 14A through 14K, and that's all we're offering right now. We've already requested, the court has granted our motion for judicial notice of the United States life expectancy table, which is 26, and the United States Department of Treasury internal review 1040 ES form, which is 27.
All right. So which of those, if any, does SAV object to?
Yes, Your Honor. SAV objects to exhibits 20 and 22. Those are expert reports. They're here saying.
He's not offered those.
Yeah, I understand. Okay, so if we're only going over what's been offered, then as to what's been offered as of now, no objection.
All right. What about Sunbelt?
Yes, Your Honor. We are objecting to exhibits 2A, 5A.
Oh, wait. 2A,
Yes, I believe he said 2A.
okay, but not 2B. All right, so 2B is admitted, 3 is admitted.
I'm sorry. I'm sorry, Your Honor. I'm sorry. I believe
He started with 3.
I didn't realize he said 2B as well. If he said 2B, then we are objecting to that as well.
Okay,
We're not, the next one we are objecting to is 5B.
the gasoline cans,
Yes.
right, on what basis?
Lack of foundation, relevance. I believe there is testimony that there were multiple fire cans back there as well.
We'd already talked about this, I thought.
Okay, I'm sorry, I must have missed that. I apologize.
All right, I thought there was not already agreement to admit in. We had a whole discussion about bringing them in and all that kind of stuff.
Yeah, Your Honor, to be clear, it was SAV that issued a subpoena, and I was not on the docket call. Ms. Garcia was, but you are correct, Your Honor, that we subpoenaed all 4 gas cans, which I believe were in the possession of plaintiff's counsel.
All right, I apologize if that was addressed.
All right, 5B is admitted.
Okay. 6A through C, we object to those as they contain statements that are hearsay within hearsay.
Body camera video is you're objecting to?
Yes, sir. They contain statements from the individuals on the scene, and we are objecting to those as hearsay within hearsay.
Okay.
If you want the response, Judge, that 6B is the interview with Jose Blanco, who's the supervisor of pawn operations for Sunbelt Pawn by the IFD. And 6C is the IFD's interview with Sabino Venegas, who's the principal and owner of SAV Enterprises. Both of those are going to be admissions by party opponents.
Yeah, that's what it seemed like. All right, 6B and 6C are admitted. What about 6A? Is that just the depo's and written question? Yeah, 6A is admitted. All right, what else do we have?
Your Honor, as it relates to the photographs, we just believe that those are cumulative and duplicative. They're just multiple photographs showing what we believe are the same injuries over and over. And that's for 9A and the 10 photographs for the 10 alphabets, as well as the 11 alphabets, 11 exhibits, all of those.
All right, based on that objection, those are overruled and those exhibits are admitted. What else do we have?
12E for Kindred Rehabilitation Hospital, Your Honor. We do not believe that those records have been authenticated and proven up. We have not seen any business records affidavits unless we're missing something.
Mr. Smith, is there a business record affidavit that goes with that?
For number 12E?
Yes.
Yes. Hold on, Judge. Let me make sure I just didn't misrepresent something. Because Miss Vega is holding up the finger. No record sheet. Okay, that is accurate, Judge. There's not a business records affidavit for the medical records. Okay. We'll withdraw our offer of that, Judge.
That's over 20,000 pages of documents. You're not going to try to offer that?
No, just 12E, Judge. The only one she's objecting to there on is 12E, which the Kindred.
Oh, I'm sorry, I misread that. Okay, I see.
I'm sorry, Your Honor. Did counsel say 12E as in Edward?
Yes.
Okay, I misheard.
Yeah.
All right, 12E is withdrawn as I understand it.
Yes, it is withdrawn.
Okay.
we'll see if something changes between now and later on.
Okay,
On 12A through D,
all those are admitted. And F. Any other objections, Ms. Washington?
No, sir.
All right. So all the other exhibits that were offered that were not objected to are admitted. Okay, what about let's deal with
2A, Judge.
yes.
So 2A is the City of Irving Department Incident Report. It has all of the matters that were observed by the Irving Fire Department in the course of their investigation. That is proved up by custodial affidavit. I suspect that their big issue to it are the statements by Jose Blanco and Sabina Venegas that were made to the Irving Fire
Mr.
Department.
Smith, we'll deal with 2A and 2B at trial. We'll just we'll deal with those at trial. So let's deal with the trying to find the exhibits. Okay. The defendants, Wilbur Venegas, Jose Blancos, and Premier Option Credit, that is also known as Sunbelt. Is there which exhibits are you offering for that one, for Sunbelt?
Yes. I'm pulling it up. We are offering all the ones that are on there. I believe it's 3 or 4.
It says 1 through 9 on my list.
Okay, sorry, let me. We are offering whatever the. All right, yes, Your Honor, we are offering 1 through 9 on the list.
That's on Sunbelt's list.
Yes,
Right.
correct.
Okay. Any objection to 1 through 9?
None for SAV.
Mr. Smith?
Did Ms. Washington start to say something?
No, go ahead.
Okay. I only have objections to number 1 and number 3. Number 1 is the commercial lease. The only portion to that to which I'm objecting is a statement in there that SAV shall have no liability for the conduct of Sunbelt's employees. I think that gets into a matter of law. That's not really a fact question for the jury. If that's redacted out, I don't have any issue with the admission of exhibit number 1.
You agree to that redaction, Ms. Washington?
And I believe we would like to offer the commercial lease whole as it is without that redaction.
Okay, well, let's deal with that at trial. What about 3?
3, we have objections on the grounds of relevance and 403 prejudice. Those are a series of certificates that don't have anything to do with fire. It's a plumbing certificate, there's an electrical certificate, there's a certificate of occupancy. They're just not relevant. I think they're unfairly prejudicial, distract, and confuse the issues.
All right, Your Honor, we will agree to that objection.
So you're going to withdraw that exhibit?
Yes, sir.
Number 3, defendant Sunbelt's 3 is withdrawn. Okay, let's deal now with defendant SAV's exhibits. Which ones are you offering?
Your Honor, we're offering all 8 of our exhibits.
Any
And
objection? I'm sorry, go ahead.
oh, I'm sorry, Your Honor, one clarification. We're going to withdraw 4. And so we're offering 1 through 3 and 5 through 8. And just to foreshadow this, one of our exhibits is the same as what's on Sunbelt Ponds. It's the same lease. So we can deal with it at trial as to Mr. Smith's issue with that section.
I'm sorry, what I got a little, which ones are you
I'm sorry, Your
offering?
Honor, I'll slow down. SAV is offering 1 through 3 and 5 through 8.
And not the UTMB radiology records.
Correct, Your Honor. And
Okay,
then exhibit number 2 is the very same lease that was exhibit number 1.
so we're gonna wait on admitting that one then.
And we'll wait. Yes, Your Honor.
All right, so number 1, any objection by either party, either other party?
No.
Mr. Smith,
No, Judge.
Ms. Washington,
No, Your Honor.
1 is defendant's SAV, 1 is admitted. Number 3. Any
No.
objection, Mr. Smith?
No objection.
Ms. Washington,
No objection.
3 is admitted. Number 5, 6, 7, and 8, any objections by plaintiff,
No, Judge.
by Ms. Washington?
No, Your Honor.
All right, 5 through 8 are admitted. Okay. Let's now deal with line and page designations. There's a lot here, so which one do you want me to look at first? Are any of these folks actually, so there, it looks like there's 5 potential depositions. Are any of those people are you gonna actually play any of those or read any of those, or are these people are gonna be called live? So it's Wilbur Venegas, Sabino Venegas, Jose Blanco, Angel Vargas, and Dr. Savant.
We'll be calling those witnesses by deposition testimony.
All 5 of them?
Yes, Judge.
Okay. All righty. So let's deal with the objections. Which one do you want? Which one's going to be called first? Because I don't know how much of this I'm going to be able to get through.
Sabino Venegas.
All right. So go to Sabino Venegas first.
Your Honor,
Yeah.
this is Bob Ragalone. I just wanted to interject. Some of these witnesses, I believe we're going to bring live. So we can obviate this exercise.
Yes, Your Honor. Sabino Venegas, we are bringing live. He is the only person affiliated with SAV. He's SAV's owner. So I don't understand why there would be any deposition play.
Because I want to call him by deposition testimony, Judge, which I'm allowed to do in Texas.
Yeah, he's allowed to do that if he wants to. I mean, he can call him during his case in chief by deposition, and then you can call him live if you want.
And Your Honor, for clarification, will Mr. Smith be permitted to cross-examine him twice by video and then live?
It depends on he can't cover this. It's just consider it like the person is,
Is all live.
If it's cumulative, then consider it's all live. So if it's cumulative, you can object as asked and answered. But I mean, you're asking me to kind of rule on something. I don't know what's in the deposition. I don't know what's going to be testified at court. So just pretend like it's all as if Mr. Sabino testified live at trial. And if it's cumulative, you can object at that point. All right. So what are the objections, I guess, that I need to rule on for Mr. Sabino Venegas's deposition?
Your Honor, we have several. The first objection, maybe, Your Honor, you tell me if this might help the court. I have the transcript pulled up and I
have the transcript here too, just FYI. So
okay.
You just give me line and page, I can go to it.
Certainly, Your Honor. The first one is page 72, line 4 to page 73, line 1. The objection is irrelevance.
Well, wait, page 72, line 4 through
73, line 1.
Okay, let me read it. Overruled. Objection, I mean, so objection to that is overruled. What's next?
Page 75, line 23 to page 77, line 13.
Sorry, 75, line 23 through what?
77, line 13.
Yes, Your Honor.
Any of the objections, Mr. Coleman?
Your Honor, allow me to maybe give some context here. The objections that we're making to these sections of the deposition deal with this issue that's been spoken about in this hearing, which is what Sabino Venegas did post-incident related to the gas can. And again, the argument here is it's not relevant to any material fact in the case because it doesn't make it more or less probative who was supervising Mr. Torres, if anyone, as to how he cleaned the floors, who instructed him, if anyone, as to how to clean it, and whether anyone other than Mr. Torres knew that day that he chose to use gasoline to clean the floor. None of this question is about that. It's all about, okay, did you take the gas can out back?
Okay, Mr. Feldman, I have a lot to rule on. I think I've read this. I'm familiar with the case. If I need argument, I'll let you know. I don't need argument. Objections overruled. What else do you have?
Page 77, line 22 to page 78, line 2.
Okay. Overruled.
Page 78, line 15 to page 79, line 2.
Overruled.
Page 79, line 18 to page 84, line 11.
So why, I guess, do you need, Mr. Smith, 79, line 8 through 80, line 1? Is there some question that maybe they coached the witness or something?
Yes, Judge. The testimony that you just read is an impossible set of facts where all of the evidence was still in the hallway or in the office when they all got back together, and then everyone was accounted for. So there was no possibility for anybody to hide any of it. Mr. Robb requested a break. Then he was out with his witness for 17 minutes, and then he came back in and he changed his testimony and testified that that in fact was not true.
Your Honor, to be clear, I believe in this section, and I want to make sure we're all hearing each other. The objection was to 79, line 18 to page 84, line 11. And if that whole stretch is played continuously, it includes a break, a going off the record, and the court needs to know that these depositions were happening through interpreters. That was the case with Sabino and with Mr. Torres as well. I understand that, opposing counsel may want to characterize what was going on, but, the testimony is the testimony. But I guess I need clarity. Mr. Smith, do you want that entire section played, including this section that talks about going off the record, coming back on the record?
Yes. Yeah. He testified to one thing, and then he left the room, and then he came back and he changed his testimony. That's relevant, and the jury gets to listen to that and weigh it along with all the other evidence regarding Mr. Venegas's credibility. I mean, credibility is key in this case, and the veracity of these witnesses. And it's not just the statements that they made to the fire department out there at the scene. Even in the course of his deposition, he's still telling stories.
Yeah, I think this is all fine. It's objections overruled. What else do we have?
Your Honor, page 85, line 14 to page 86, line 10. And Your Honor, let me flesh this out because this is different. You will see that there was a form objection there. The question is an improper question. It's actually misleading and it's a legal conclusion. The very first question in that stretch is Mr. Smith states, you understand, Mr. Venegas, that if you told me something before that's not true, those are lies.
What line are you on? 85, line 14?
I'm sorry, Your Honor, I lost my step. I was on 84. Let me look here. 85:14 to 86:10. Okay, Your Honor, the objection here is the same relevance argument.
Oh,
Same
overruled. Overruled. What else do we have?
Page 88, line 20 through page 89, line 10.
Overruled.
Page 89, line 24 to page 90, line 3.
Yeah, overruled.
Then page 90, lines 5 through 9, 11. And then lines 13 through lines 23 on the same page.
And just so it's clear, Mr. Smith, you need to take out the objections forms wherever they are.
There are a couple of places, Judge, where, and we've tried to do that.
If you can.
Right. We have tried to do that. There's a couple of places where it just doesn't cut well. Just, as you well know, people get to talking over one another.
Yeah, I get it. Okay.
Your Honor, the next
that's overruled.
The next objection is page 97, line 1 through line 7.
Okay, overruled.
Page 103, line 14 to line 25.
Overruled.
And those are that's the final objection is to Mr. Venegas's deposition.
Miss Washington, I'm sorry. Did you have any additional?
Yes, we only have for Savino Venegas, we only have line 5420 through 5515.
Let me look that up real quick. Overruled. All right. What else do we have? Good on with Mr. Venegas. All right, Mr. Smith, what's the next one I need to go over?
Jose Blanco, Judge.
Okay. What's the first objection? If any?
For SAV, Your Honor, it's on page 72. And let's see here. Page 72, line 25 to page 73. Line.
Yeah. I'm sorry, go ahead. It's the only thing that's listed is 72:14 through 18. Is there more than that? Or only thing that's highlighted?
72:14. Permit me one moment, Your Honor. We don't have an objection to 72 lines 14 through 18.
Okay, what is your objection then?
And for some point of clarification, Judge, these first four objections are incomplete designations, which is basically an optional completeness designation. Normally, they would identify what testimony they want added in. What we did in the amended exhibit list is go ahead and add in the full testimony to address what those objections were on those first 1, 2, 3, 4, 5 incomplete designation objections.
Is that correct, Mr. Feldman?
Well, Mr. Smith, I just point of clarification. Are you saying that for the objections where we listed incomplete designation, you've now designated those lines?
Well, there's not lines identified on the objections as to what to designate. So y'all objected to 7225 through 7217. And what we did is we moved back to designate 7214 through 7218 to try to capture what we thought we were trying to add into those.
And how about for the next one on page 83?
Yeah, you have an objection on basically what's optional completeness, 83.7 to 83.15. We added in 82.24 to 83.15 to capture the testimony above it.
Okay, we have no objection to that section.
Just let me know what do I need to rule on, just so I can kind of get to that.
Yes, Your Honor. I just want to make sure there's 3 more of these that were an incomplete designation objection. So
Then you guys talk amongst yourself. Just tell me what I need to rule on if there's anything else.
Let me try to help you out here, Mr. Feldman.
Thank you.
Next one was 84.9. We went ahead and moved up that designation to 84.4 to capture that testimony. And that runs through 84.15.
Okay, I agree. That cures that objection.
And 84.35, we went ahead and moved it up to 84.35 doesn't exist.
Yeah, that's a typo. I'm sure it's 84 line 5.
I thought it was 84.25. We moved it up to 84.24. So you can check it and see if that addresses your concern.
I believe it does.
And then you had 86.13 through 86.22. That one is still as is.
Let me look at that. I've got 86.13 it's in the middle of a question. It's the last. So that doesn't quite make sense. The question begins on line 8.
Yeah, so line 8 has a summary. Oh, wait, Judge, are you there?
Yeah.
The only thing that we're designating there is the question, then what?
Oh, so you're beginning with the words, then what?
Yes, sir.
All right, then no objection. All right, I believe that takes us to page 89, line 21 to 90, line 9. And our objection is to the irrelevance of the testimony. Again, this testimony doesn't have any bearing on making any material fact more or less probable.
Okay. Overruled. What else do we have?
Your Honor, the next one would be page 98, line 4 through line 13. And then on that same page, skip to line 15 and carries over to page 99, line 3. It's the same objection, Your Honor.
Overruled.
Then page 99, line 5 through 21.
Overruled.
Page 101, line 7. This is an incomplete designation. it doesn't seem like the question is included.
Of course, what I have, it's 101 line 1 through 7. Is that not right?
Okay, let me look at that.
This is another one of those incomplete designations that we moved up to attempt to address the objection.
So it's now line 1 through line 7?
Yes.
Okay, I believe that cures the objection.
Okay.
And so you don't have line 9 because that just seems duplicative.
Yes, that is correct.
Okay. So then skip to page 102, line 3.
No, I'm sorry, I misspoke. We do have line 109, 1019 in there.
Correct me if I'm wrong, but the only thing, he answers the question in 7, and then there's an objection to form, and then he just says the word okay again.
He says yes. Okay, yes.
Objection
Oh,
to-
okay, you're taking the form objection out? Were you able to do that?
We've tried to, like
You
I
could
said,
take line 7 out and you still get the answer in line 9. Because he says, okay, yes.
well, that's not how we have it. We've got it.
I don't want, this is still, objections overruled. Let's move on.
Moving on to page 102, line 3. To page 103, line 6. The objection is irrelevant.
Okay, that's the only objection overruled.
Can we move to page 103, line 25 to 104, line 6?
103.25.
Yes, Your Honor. Oh, actually, it carries through to 104, line 15.
Yeah, overruled.
Go to page 119, lines 11 through 23.
You said 119.11 through 23.
Yes, Your Honor. This is all the testimony about post-incident conduct. It is immaterial. It does not make it more or less probable as to whether anyone was supervising him or instructing him to use gasoline.
Overruled.
Next objection, Your Honor, is page 121, line 15 to 121, line 22.
All right, what page again?
121, Your Honor, lines 15 through 22.
Overruled.
Then pages 122, line 10 to 123, line 1.
Overruled.
Then lines 9 through 19 on page 123, Your Honor.
Overruled.
Then we go to page 130, beginning with line 22 to or through page 132, line 2.
Yeah, this seems
this-
a little, okay, this is a little different, right?
All right, now, Your Honor, these objections are different in kind. They're not the issue with post-incident conduct or relevance on this basis.
Right. That's what I said. All right, what's your objection to this?
Several of these questions in this series call for legal conclusions. There are questions about they would have control. They would have control. And so there are objections to form here. They're asking the witness basically to make a legal conclusion. Of course, control will be an issue for the jury to decide based off facts. Okay. I mean, clearly you can ask, what were you doing? What did you say? What was your position? But that's not the question here. It's basically calling for a legal conclusion from a lay witness.
I guess the main part I may have an issue with is 131 line 4 through 11.
Yes, Your Honor, that's the core of it. When it's being asked, would also have control. That is a core legal issue in the case. Mr. Blanco is, obviously not the judge of the law. Only the jury is the judge of the facts. Again, it's totally fair game to say what Jose Blanco was doing, what his title and position and responsibilities were with Sunbelt Pawn, but that's not the question.
Okay, response?
We are looking, just for point of clarification, at 131 line 4 through 11.
Yeah.
Yeah. So what I hear Mr. Feldman saying throughout these objections, particularly with respect to what they did after and what they said, is that it doesn't have anything to do and no factual relevance to whether they instructed to use.
Yeah, and I think what he's arguing on those particular ones is that this is asking for a legal conclusion.
Yeah, I don't think that that's what that is, Judge. I mean, you've got Jose Blanco, who is the supervisor of pawn operations for all of the Dallas area stores. He was the one that was set by Sunbelt Pawn to oversee and direct the work of Carlos Torres and Mario Reyes on behalf of Sunbelt Pawn. And what he's testifying to is what level of control the people on the work site have over the people who are on the bottom of the chain of command.
Your Honor, I need to respond to that. First, in lines 4 through 6, that's where Jose Blanco, who's not employed by Sabino Venegas, again, just so the court has the context, Sabino is the sole owner and member of SAV Enterprises. Jose Blanco is not employed by SAV Enterprises. Nobody is, other than Sabino himself. Then you have Antonio Venegas. He is affiliated with Sunbelt Pawn. And right here, Jose Blanco is being asked whether my client, Sabino Venegas, has control. So first, it's doubly concerning because not only is it asking him to call for a legal conclusion, but it's asking for him to speculate.
If I may address that last one.
And another thing is the intention of the question is irrelevant. The harm here and the impropriety of it is a jury will be misled as to thinking that because Jose Blanco answered yes to a word about control, then, oh, well, then that means Sabino Venegas controlled him. And he didn't.
Yeah. So if I may address that, this goes back to this kind of course of conduct that took place. Here's the way that this would work, Judge. There's 8 buildings that are Sunbelt Pawn stores that are owned by SAV Enterprises and leased to Sunbelt Pawn. When SAV Enterprises would buy these buildings and lease them into Sunbelt Pawn, there was renovation work that needed to be done on all of them to get them in the stage where they could be used as Sunbelt Pawn stores. What would happen is Sunbelt Pawn would send its employees to do the renovation work, and at each one of those renovation projects, Sabino Venegas would show up. This is one of 5 stores that is in the Dallas-Fort Worth area. This renovation work started in February of 2019 and had been going on for approximately about a month by the time this incident took place. Sabino Venegas was out there on the work site every single day that work was taking place on this work site with Jose Blanco and Carlos Torres and Mario Reyes. And Jose Blanco, on this renovation project and on other renovation projects, got to see how everything worked with respect to what was Sabino's role, what was Jose Blanco's role, what was Anthony Venegas's role, and what was the role of the workers underneath them on these renovation projects when they took place. And that's what these questions are going to. What is the chain of command, and who has a role in supervising and directing the work that is done, and who has the authority to say, do this or don't do that?
Your Honor, I understand what Mr. Smith just argued, but that's not what the question is asking. It is clearly calling for a legal conclusion. When Jose Blanco is asked, and Sabino Venegas would also have control over what they do and what they don't do, that's asking him to admit a legal conclusion that, one, he doesn't have a basis to admit, and two, it's a legal conclusion. Again, if the question was,
I've heard the argument. I'm going to go ahead and overrule that objection. What else do we have?
page 135, line 22. Through page 136, line 12. Your Honor, it's the same issue here. A lay witness is being asked.
Overruled. What else do you have?
Page 138, line 7 through 138, line 13. There's several objections here. It's irrelevant. It also calls for speculation. Mr. Blanco didn't have a foundation to even answer that question.
Response.
The question is what they didn't do. And he said that there's a couple of things there. And all those are questions regarding the facts of what they did and did not do.
It's a you'll see there's an objection to form, and there's a lot of problems with this question. First of all, it's compound, and Sabino doesn't employ Mr. Blanco, and the question is asking him to basically answer on behalf of not just Jose himself, but Sabino Venegas about what Sabino did to get some tool. And nowhere in this deposition does it establish that Mr. Blanco knew.
Overruled. What else do we have?
On the same page, Your Honor, lines 14 through 21, or 14 through, I guess to include the answer. Really, it carries over to page 139, line 7.
Overruled.
That's our final objection, Your Honor.
Ms. Washington, do you have any additional objections?
Yes, Your Honor. If we could address 83, 7 through 15. We had incomplete. I don't know if he addressed that with the subsequent 84.
Yes, we did. 83, 7 through 83, 15 we talked about. We moved that up to 82-24.
Okay. All right. So we can skip.
Go ahead, man.
We can skip down to 98, 4 through 13.
Okay. I think I already ruled on that, but overruled.
90, and I was trying to make note of the ones.
I may be wrong. They're just similar to other stuff. So what else is there?
All right, I believe 98, 15, 03, you already overruled, so we can skip that one. We can skip 99, 05.
Yeah, and I'll assume that just assume that any objection that they made that you also made, if I would be ruling the same way.
Yes, sir. That's why I was trying to go through and mark at the same time as well. — 128, 22 through 24.
Okay, 128, what?
22, line 22 through 24.
Overruled.
129, line 3. Well, I guess 3 through 12. I'm sorry, line 3 through 12.
Overruled. Anything else?
One I am double checking. Okay, the rest you've already overruled.
Okay. All right, what's the next deposition I need to look at? And we're running, and I will say we're running out of time, so just try to get through these quickly as we can.
Judge Rod, how much more time? Because I may need a quick break.
Why don't we take a quick 5-minute break and you guys can confer on what you guys need to do next.
Your Honor, a quick question is, I apologize. I see that Rhonda Pinson is your coordinator. I'm not familiar. Ms. Rieger, are you the court reporter? I wasn't sure whether.
Yeah, she's the court reporter.
Okay, thank you, Your Honor.
No problem.
5
We'll
minutes.
take a 5-minute break.
While the court is on break, Mr. Feldman and Ms. Washington, we've got Antonio Vegas. I don't see that SAV has any objections there. It looks like.
Right, I'll just say that our objections were just to Jose Blanco's deposition and Sabino's, so. For
So,
SAV, we're done.
yeah, and that means I just see 2 depositions that have objections to
That's
them.
correct. We
Sunbelt,
only have to-
and that's 2 objections to Anthony's and 1 objection to Angel Vargas. Let's see if we can reach some agreements on that. I think that given the court's ruling, that objection to 32.3 through 32.7 will wind up being overruled. That's the testimony regarding Jose Blanco calling Anthony and reporting just that there had been an accident at the store.
Okay. For 32, I agree that the judge would probably overrule that. For line 39, we'll let the judge rule on that one, unless you agree.
No, I think that's relevant.
Okay.
On 32.3, 32.7, are y'all withdrawing that one?
Yeah, I agree. I think the judge will overrule it.
And then that just leaves 1 objection to Angel Vargas on the after-tax calculation of the wages based upon the 1040 ES form.
Right, we'll let the judge rule on that one.
So that just leaves 2 objections on for the defendants. And then, so that everything is even, I do not see that Premier made page line designations. Is that accurate, Ms. Washington?
Yes.
So that'll just leave our objections to SAV's designations. On that first one, Mr. Feldman.
Give me 1 minute. 1 second. I'm gonna get there.
That's on Angel Vargas.
Oh. Okay, which part?
44.2 through 45.18, and that's an examination of Mr. Vargas of Mr. Torres's legal status.
Oh, okay, the illegal immigration issue. Well, the court has made its ruling on that clear. Let me just double check those lines, but if that's so, then we're gonna withdraw that. So I'll check it Okay, anything else on Angel Vargas?
There's 47.2 through 47.3. You can see my objections there, and for your convenience, I went ahead and cited the deposition testimony that shows that it's misleading and it's a mistake of Mr. Torres' deposition in his testimony.
You said 47 lines 2 through 3?
That's the statement that he, being Carlos, testified in this case that he cannot read English. And I've quoted for you the actual deposition testimony where he says that he can read some English.
Give me 1 minute. I'm trying to pull it up. I'll look at it. Huh? Okay. Anything else on Vargas?
53.21 through 54.2. That's an examination regarding pay stubs. Obviously, we asked Sunbelt Pond for pay stubs and didn't get any. So
So we designated that, but Ms. Washington did that cross-examination, so we'll let her handle that. But I believe, based on the court's prior ruling, that's my understanding was that the discussion of the pay and the pay amounts can come in. So
On the motion in limine, I want to make sure we're taking notes right. He denied the motion in limine about reference to W-2s. Do I have that right?
yeah, pay stubs.
And pay stubs.
Income information that we had requested from Sunbelt but didn't get.
I'm sorry, Justin. It may be my computer, but the volume that I'm hearing is not that loud for the court. I hear the court fine. I just hear you a little soft.
It's probably the microphone on my laptop, Brian.
Yeah, you are a little quiet, Mr. Smith, but all right, what else? We have a little bit more. Oh, Tony, are you back? Tony, are you back? You can't go on the record yet, but why don't you go ahead and tell me what the next deposition I'm going to be looking at is?
Wilbur Antonio Venegas.
All right, there's Tony. What's the first page I'm looking at?
What are we doing, Judge? I'm sorry. I didn't get the first half.
Okay, sorry. We're reviewing the line and page designation objections to the oral and videotape deposition of Wilbur Antonio Venegas, Vanegas. All right, what's the first objection?
So line 3907 through 10.
Overruled.
Okay, that's all for Wilbur. And then the last deposition we have is Angel.
Oh, wait. What about the other defendant? Do you have any objections?
I'm sorry.
You're muted.
No, Your Honor.
Okay, what's the next Okay, Mr. Smith, what's the next deposition?
It's Angel Vargas, the Vocational Rehabilitation Counselor.
Okay.
And Your Honor, during the break, to be consistent with the court's ruling on the immigration status issue, we're going to withdraw the designation of a line 44, page 44, line 2 through page 45, line 8, but keep the...
Out of Angel Vargas?
Yes, Your Honor.
Okay.
But just so to be clear, lines 9 through 18 on page 45 do not get into that issue, and those are still designated.
All right, what's the first objection?
Judge, I'm getting a little bit out of order because he's going to address plaintiff's objections to their deposition designations. I think for clarity's sake.
So why don't we do plaintiff's objections first, and then we'll do defendant's objections. So, and I assume, Mr. Smith, for the previous depositions, you didn't have any objections, correct?
for the previous depositions. No, I only have objections to their designations on Mr. Vargas and on Dr. Savant.
Okay, I should have asked that earlier. Okay, let's deal with the plaintiff's objections to Vargas first.
Well, then that gets us to what Mr. Feldman was talking about. Let me get to this deposition. That's 44-2 through 45-18. And I understand that he has withdrawn. Which page and lines, Mr. Feldman?
Page 44, line 2 through 45, line 8. So we're just down to lines 9 through 18 on page 45.
No, 45 or 44?
45, Your Honor.
Okay, give me the page, give me the lines again.
45, lines 9 through 18.
45, line 9 through 18.
Yes.
A response. Mr. Smith, what's the basis of your objection?
The predominant basis of my objection was addressed to 44, line 2 through 18, which is discussing his legal status. With that excised from that designation, I don't have an objection to that, Judge.
Okay. All right, what else do we have? Any other objection by plaintiff?
We do. We have 47, line 2 through 47-3, and that is a statement that's attributed to Mr. Torres that he testified in his deposition that he cannot read English. I have an objection to that being misleading under 603, and attorney testifying under 603 and misleading under 403, because that is not in point of fact Mr. Torres' testimony. I've cited the testimony itself and quoted it in the objections.
Overruled, you could deal with that on redirect if you need to, if that's addressed, but that's overruled. All right, what else do we have?
We have 53, line 21 through 54-2. That's an examination regarding pay stubs, which again we have requested in discovery from Sunbelt but didn't get.
Your Honor, I believe Ms. Washington may speak to this. She was the questioner in that series of lines, but I understand the court denied the motion in limine about keeping out evidence of W-2 or pay stubs. So I don't know why the deposition testimony.
Let me ask Mr. Smith, what's the basis of your objection?
I thought the court granted the motion in limine keeping out references to pay stubs, W-2s, and 1099s introduced to us.
Let me go back a little bit.
So let's talk about this. So the motion in limine, as I understood it, was whether or not he'd reported his taxes. That was what the motion in limine was about. And I granted that motion to keep out. This isn't about whether or not the plaintiff has paid their taxes. That's a different court at a different time if that ever comes up. But so I don't know about W-2. I haven't ruled on any issues involving W-2s or 1099s.
Very good, Judge. And then let me address that specifically
Okay.
in the context of this deposition testimony. So Mr. Vargas, as I mentioned, is a vocational rehabilitation specialist. He relied upon what Carlos relayed to him regarding his income from Sunbelt on a weekly basis.
Okay, I've read this now. So 53, 21 through 25, that can come in. But 54, 1 through, or did you submit 50? Are you asking to submit 54? Page 54?
Yes, the designation goes to line 2 of page 54.
pay stubs. What exactly is a pay stub? Is that, do you mean like it's not a 1099, that's just a.
Correct, Your Honor, like, someone who's paid on a biweekly or
Okay, I
monthly
get it.
basis.
Yeah. I think one through two are okay, but you can't go beyond that. So objection to one and two are overruled.
And I believe the court said that 5321 through 5325 was also overruled. Is that
Right.
correct? Okay. So overruled. All right. We'll withdraw our objection to Shelley Savant's 7823 through 796 to move this on.
Does plaintiff have any other objections?
Yeah, that's all of them.
All right. Does defendant have any objections?
Your Honor, on Angel Vargas, we objected to line 3512 through 3811.
All right. So you said, let me get to that. 3512 to what?
3811.
It's a lot. Let me see. Okay, there's a lot there. So what's the basis of the objection?
Your Honor, we objected that there was a lack of foundation there. There was a lack of personal knowledge. We also objected that it was outside the scope of his expertise.
Response?
Yes, Judge. As you well know, we have to present Mr. Torres's lost wages, lost earning capacity, and after-tax dollars. This examination is running through the 1040 ES form, which the court has taken judicial notice of, to calculate the after-tax.
The way I've always done this in the past is I usually just have them do their gross, and then afterwards, then it's reduced. But what do you think?
If I understand what the court is saying, present the gross amount of the lost wage and lost earning capacity to the jury, and then after the jury returns a verdict, take the amount of the lost wages and lost earning capacity, and then reduce it to after-tax in the judgment.
Yeah, that's how I usually do it. Does anyone have a problem with that?
No, I don't have a problem with that, Judge. If everyone else is fine with that, then I don't have an issue doing that. It'll streamline some things, and it's just math.
Are you okay with doing that? I think the concern I have, and I assume the defendants might share this, is that it doesn't seem fair to say that, to imply that the plaintiff has been paying taxes when he hasn't actually been paying taxes, apparently, right? And so it would seem to me that this is not a ruling, that the best way to do this is do gross and then take out the taxes if it's awarded, and not go into, this whole tax calculation. But Mr. Feldman, what do you think?
Well, Your Honor, I think I understand what you're saying, but just a point of clarification. So would plaintiff's expert on this issue in front of the jury provide the opinion about the tax rates that would apply to his opinion? I'm just a little unclear mechanically as to how this would be done.
Again, this is not a ruling. This is just a suggestion.
Understood.
I would say that you would, if you can't reach an agreement as the tax rate, then have him testify outside the presence of the jury on that. if you can't just reach an agreement.
Well, then, yeah, I'd like an opportunity to talk about it with Mr. Smith.
Okay.
Yeah.
We want to hold off on when are you having Vargas testify?
Probably on Thursday.
Okay, so why don't you guys talk between now and then on that issue? Is there any other objection besides stuff about taxes on Vargas?
None from us.
Mr. Feldman?
I'm sorry, is Mr. Vargas live, or is he by deposition?
By deposition.
Yeah, we're going to have to figure out how you would do this exactly with the deposition. So I'm trying to be fair to both sides here. And so if there's a way to do it without implying that he's paid taxes, I think that's.
Yes.
Understood, Your Honor. Yeah, we'll just need some time to look at it mechanically, how we could designate and figure it out.
We have designated the testimony regarding the gross, and then what happened in the depositions, we regarding the gross, and then we had testimony because we're required to present it in after-tax dollars. So if we have an agreement to just let them testify as the gross and then reduce it.
Yeah, if that's the case, it seems pretty easy. But you guys talk it out. I'm not trying to force anyone to do anything. It's just that seems to make the most sense to me. But that's up to y'all to talk about. All right, let's deal with Shelley Savant. I have about 15 minutes left.
There's no objection to our designations on Dr. Savant, and we withdrew our one objection to their designation.
Okay. So nobody has any objections to Savant?
No.
No, Your Honor.
Okay. All right. Anything else we need to rule on for tomorrow?
Two matters, Your Honor. Back when this case was set in January, a Rule 166G motion was filed by SAV Enterprises. This may be a non-issue. I'm a little unclear. The pleading had a strict liability theory in there, but the jury instructions that have been proposed by the plaintiff doesn't have any questions on strict liability. So before I don't want to beat a dead horse, Mr. Smith, has that theory been withdrawn?
Yeah, we don't have it in our proposed jury charge and don't intend to present that in the pattern jury charge. I read your brief. It's a good brief and your points are well taken.
Well, Ms. Garcia gets all the credit for that one.
All right.
So just clear, we all agree that gasoline use in and of itself does not qualify as an inherently dangerous activity, and a strict liability theory is not going to be presented at trial.
Yes.
Okay, great.
Okay, and then, Your Honor, the only other housekeeping matter is a motion for bifurcation was filed back in January, and under Chapter 41, defendants have an automatic right.
Granted.
Okay, there was a proposed order filed, so
can you just submit that to me tomorrow because I don't have it?
Yes, Your Honor.
Or actually, maybe I do. When was it filed?
Let me look at the exact date. It would have been back in January of 2023. May take me a second, Your Honor.
It was filed on January 26th, Your Honor.
Give me 1 second. Okay, I see it.
And then just a clarification. I know this was addressed last Friday. I was not on the Zoom docket call, but we worked out how the gas cans would be brought into the courtroom.
Yes. We're gonna talk to the bailiff that's gonna bring them in. I think we had also agreed it would just be one gas can, I think.
All four of them are in an evidence bag.
Oh, you're right.
Yeah.
Never mind. It's all four. I forgot that. You were correct.
With that, Your Honor, I don't think we have anything else to address.
I have a couple of housekeeping matters to address if the court has some brief time.
Sure.
My recollection, Judge, is that the court pre-qualifies the jury downstairs before bringing it in to the courtroom.
I don't do it. The central jury room does.
Okay. What is our start time tomorrow, Judge?
Typically we start at 9, but we've done most of the pre-trial, so But I would encourage you, if you haven't already, to try to use the, are we having any Zoom witnesses?
No, Your Honor.
Okay, the new equipment is the most complicated part is for Zoom witnesses. The rest of it is pretty similar to what we had before. There is one additional feature that you guys might want to use, is we have what's called a barcode that allows one laptop to be attached to the AV equipment remotely. So you guys might want to try to use the barcode, because I know there's two defense lawyers here, so that one of you can be attached through the hard line and then the other one could be attached remotely through barcode. But it doesn't work with every laptop, so you might want to kind of test out the barcode in the morning, if that makes sense. If you think you're both going to be using exhibits, so you don't have to go back and forth and attach and unattach exhibits. So
Yes, Your Honor. On that point, when is the courtroom door unlocked?
It's supposed to be unlocked at 8:30, but that's when my bed's supposed to. I'll text them in the morning.
And on that point, is there a specific software that's used for that so I can pre-install it?
It's brand new, so you may want to look it up to see if there's something I bet that you're going to have the biggest problem from what I've seen, because you're from a big firm and they usually have security that keeps barcode from being used.
Well, it's a very good assumption, Your Honor, but I have good news. This is my personal laptop and I don't have all that junk on there.
Okay, so then you probably should be able to use it, but I'm not, to be honest, I'm not sure. I think it installs automatically when you attach it, but you might want to look it up. It's Barco, BARCO.
Okay. And then the last thing just came to mind. I will confess, this is my first trial that's obviously going to involve the use of interpreters.
Mm-hmm.
I know Mr. Torres is going to need interpretation, and Mr. Smith, I apologize, I just haven't asked you about this yet, but do we have an interpreter lined up, or how do we want to address that?
We do, and I had discussed this with Mr. Robb and Mr. Carp at the very first trial setting of this year. And we had agreed to split the cost on the translator, because we're going to need one, and then y'all are going to need one too, for Savino. So, but we do have a court reporter lined up for Tuesday through Wednesday through Friday.
Okay, so Tuesday through Friday or Wednesday through Friday?
Through Friday.
I'm sorry, I didn't hear you.
Wednesday through Friday.
Wednesday through Friday.
All right, so let me chat about one last issue that I have, or a couple issues. One is, have you guys conferred on the jury charge?
On the jury charge, we've exchanged our proposed jury charges. And
so ideally by tomorrow morning, if you guys could confer on the charge so that we can start working towards that. It doesn't sound like it's going to be super complicated, but just confer on the charge, and so we can have some idea of what's going on with that. And then in the morning, we have one kind of logistics issue I want to kind of chat with you guys about in the morning. So I think I gave you guys an hour and an hour 10 for voir dire. Is that right?
That's correct, Judge.
Correct.
So I have a lunch thing tomorrow that I have to go to. And so I'm worried, just logistically, that we're going to, depending on how quickly we can get the jury, that we may need to break in the middle of the defendants. Maybe what we do is we do the plaintiffs and then one of the defendants voir dire, then we break for lunch, and then we do the other defendants voir dire, and and then do the rest of jury selection after lunch. But I just want to kind of let you know I'll need to do kind of a hard break at 11:50. So
11:15 or 50?
50.
50. And Your Honor, on that point, what is the court's typical lunch break routine and end of day routine as far as when lunch break is? I know it varies depending if a witness is examined.
Typically, we go from 9 to 5 every day. we usually break a little before noon and take a little over an hour for lunch. And then if it looks like we can finish the trial in a week, and it doesn't sound like we can, we can go later than 5. Sometimes I encourage the jury to go later than 5. I really leave it up to the jury if they're willing to do that. Did you have anything else?
Judge, do you typically do the voir dire and then start the openings the next day, or you try to hit
No. We get voir dire, we do voir dire, and then we jump right in. So unless it like the voir, I don't think I'd imagine voir dire should finish around 2 tomorrow is my guess. So we'll have the rest of the afternoon to do openings and call witnesses, I would think.
I suspect I know the answer to this question, but Judge, can I have 30 minutes for the opening?
How much do y'all want?
I didn't hear the question.
I believe Mr. Smith said he wanted 30 minutes for opening. Can we, Your Honor, is it all right if we get back to you at 9 a.m. tomorrow on that?
On what, the opening?
Yeah.
Yeah.
Your Honor, I don't suspect that we will need, we certainly would not request an hour for the defendants. I believe, like most other things, we will be fairly aligned on this. So we would like to share time. I don't know if sharing 30 minutes is enough. And so giving us the afternoon an opportunity to discuss, we may be able to do 40 if the court would indulge.
Yeah, why don't we talk about it in the morning? If 30 I'm okay with. Beyond 30, I don't generally allow that, but this is a little more complicated than a standard car wreck or something. So I could be persuaded to do a little more than 30.
Thank you, Your Honor.
Okay. Anything else, guys?
Just one quick thing, Judge. Does the court provide a chart that has the jurors, and do we get the jury information cards prior to voir dire starting?
Usually, yes. And it'll be better tomorrow because we've done all the pre-trials. So as soon as lately we've been getting the it varies at trial by trial, but typically we're getting the charts and packets by 9 and not getting the jury until 9:30 or 9:45. So since you don't have pre-trial, you may have some time there to look at it.
Very good. Thank you, Judge.
It's all done computer. It's not all done in the central jury room by computer.
Very good.
Anything else, guys?
No, Your Honor.
All right. We will see you guys in the morning. Is there any chance this case is going to settle? Has there been any settlement discussions?
There's no chance it's going to settle, Judge.
Okay.